nothing against, like, I love a good hysterical female song, but not like hysterical in like a charged, great, empowered way. It's just like, you know what I mean?
Yeah.
That sound.
It's not
like
cheesy. It's not cheesy.
And anyways, women are people of multitudes. And, I think that it was important to me that it didn't just feel like someone's interpretation of like male gaze. Like it really was, this is what we like. This is what we listen to. This is what makes us feel these vibes.
Hi besties, it's Katie from Without a Crystal Ball, and the question everyone is asking tonight is this. Will Judge Lyman finally recognize the alarming concerns voiced by countless individuals, including subpoenaed third parties, uninvolved outsiders, and even parties directly tied to this explosive case? Is he prepared to confront the escalating risks and the reckless way Blake Lively and her legal team have been dragging innocent people into lawsuits that endanger reputations and create massive public fallout? Shockingly, it now appears the judge is no longer ignoring these mounting issues, as he's openly declared he will consider enforcing a protective order, a powerful legal safeguard that would stop Blake Lively from unleashing more subpoenas unless approved by the court itself. Just days ago, I explained that Lively's sudden withdrawal of subpoenas had little to do with lack of evidence or successful negotiations, but rather the looming threat of sanctions against her attorneys, forcing her to backpedal under pressure. Yesterday, celebrity blogger Perez Hilton, filing under his real name Mario Lavandera, delivered his own bombshell motion for a protective order, revealing that on July 19 he was blindsided with a sweeping subpoena demanding private communications, unpublished materials, and confidential records, all because he dared to publicly analyze this case of extraordinary civic importance as part of his journalism and media commentary. And Perez is not alone. Dozens of other independent journalists and creators have been hit with equally invasive subpoenas from Lively, painting a disturbing picture of discovery abuse, harassment through the courts, and a calculated effort to silence protected First Amendment speech. What we're witnessing is Blake Lively waging a legal fishing expedition designed not for truth, but for intimidation, leaving countless creators drained, vulnerable, and forced to sacrifice endless hours and resources to defend their basic rights. What makes this situation even more intense is how the court could reshape everything moving forward. If Judge Lyman does approve the protective order, it would mean Blake Lively loses the power to casually send out subpoenas, forcing her to follow strict legal steps before involving anyone else. For creators, journalists, and everyday people caught up in this storm, that could finally bring some relief. Still, the damage has already been done, privacy invaded, trust shaken, and countless hours wasted trying to fight back. Many are now questioning if this legal drama is less about justice and more about control. The courtroom has turned into a battleground where freedom of speech collides with celebrity influence, and every move sparks bigger headlines. With Perez Hilton and others standing firm, the next hearings could decide whether Blake Lively faces accountability or continues pushing boundaries unchecked. Thousands of dollars are being drained simply to answer these baseless subpoenas, and while Blake Lively brands herself as a defender of women, her actions tell another story. She has overwhelmingly targeted women, including survivors of domestic abuse, in what appears to be a calculated strike against protected speech. Many creators remain terrified of the aggressive tactics employed by Ezra Hudson and Michael Gotadal, her lead counsel, as this court has shown minimal regard for shielding uninvolved citizens from harassment. Even today, the docket still exposes what are believed to be the private home addresses of Matthew Mitchell and Cynthia Barnes-Slater, neither of whom are parties, nor does their location serve any public good. By July 29, those links were still active, and this negligence could easily have endangered me as well, a public figure with children at home, yet the court displayed no urgency. These dangers are painfully real. In May 2025, a violent criminal set fire to defendant Steve Sorowitz's home and threatened to abduct his daughter, sending horrifying texts that read, "If you refuse, we will take her hostage and she will miss graduation. Then we will demand more money. And if you can spend $100 million trying to destroy Blake Lively's life, you can spare a few for your child." That chilling moment underscored just how grave these risks are. Therefore, I urgently implore this court to wield its authority and impose a protective order forcing plaintiffs to seek approval before serving any additional non-party subpoenas in this litigation, citing the clear standard that under federal rules of civil procedure, the court may intervene for good cause. The unfolding battle inside this courtroom is no longer just about legal paperwork. It has become a fight about safety, trust, and accountability. Families who never asked to be dragged into this conflict are suddenly forced into the spotlight, dealing with fear that grows stronger with every reckless filing. Observers are now questioning whether this case is being used as a weapon to silence voices rather than uncover truth. Meanwhile, journalists and commentators continue standing their ground, refusing to back away despite pressure from powerful attorneys. Every new motion sparks louder debates, drawing even more public attention to the question of how far influence and wealth should be allowed to reach. With shocking threats already turning into real danger, the next steps taken by the judge could change everything. Will the system finally protect those at risk, or will silence be forced upon anyone daring to speak out? A court may issue an order to shield individuals from harassment, humiliation, intimidation, or overwhelming costs, and under Rule 26(c), judges are empowered to create protective measures that stop discovery from being twisted into a weapon. When a party repeatedly engages in aggressive or harassing tactics against outsiders, especially journalists, commentators, or public critics, courts have consistently stepped in without hesitation. Protective orders become most crucial when the weight falls on non-parties, who deserve heightened safeguards against intrusive and unnecessary demands. The filing argues that this court has full authority to require prior approval for any additional subpoenas, emphasizing that other judges in this very district have granted such protections when harassment patterns were clear. As evidence, it cites Mattel versus Walking Mountain Productions, where subpoenas were used to intimidate a critic and silence public conversation, leading to a protective order. The burden on non-parties is undeniable. They should not be drained of energy, money, or legal defenses fighting vague, overly broad requests. Requiring court permission is not extreme, it is a balanced safeguard ensuring fairness. This request does not abolish discovery, but creates a necessary checkpoint where every future subpoena must be vetted by the court before service, a measured, responsible solution to an escalating abuse, not a sweeping prohibition. What makes this battle even more striking is how it highlights the clash between power and fairness inside the legal system. When wealthy figures push boundaries, ordinary voices often carry the greatest burden, yet the public is beginning to demand accountability. Each filing, each objection, and each hearing now feels like another chapter in a story that tests whether justice can truly protect the vulnerable. Observers are asking if these proceedings are about truth or simply control, and the uncertainty fuels even more speculation. Behind every motion lies a ripple effect, families unsettled, reputations questioned, and freedoms at stake. The judge's ruling in the coming days could become a turning point, shaping how far celebrities and their attorneys may go when challenging critics. Will the court draw a firm line, or will the cycle of intimidation continue, leaving creators, journalists, and everyday people exposed to relentless legal pressure? Prohibition. And truthfully, I have to admit it's shocking that a third-party journalist like Perez Hilton had to step forward and practically shout at the court, "Wake up, it's crystal clear what Blake is doing here." She is not issuing these subpoenas in pursuit of truth or justice. She's going after journalists who dared to cover her case with honesty, critics who refused to paint her as flawless. There is no evidence of payments, no orchestrated smear campaign. Instead, this is intimidation through the legal system, harassment disguised as discovery. The judge initially brushed off concerns, dismissing urgency, even as people's private addresses were exposed and subpoenas rained down without clarity or cause. Yet now, he has ordered Blake to respond by August 5th, giving room for third parties and even Wayfair to weigh in, potentially supporting protective measures. Still, the question remains, who advised her this was wise? Because every withdrawal, like today's dropped subpoena against Lynette, only exposes weakness. Already Ashley, Kenz, Lauren, Shasty, Janessa, Lynette, and several Twitter accounts have pushed back successfully, forcing her to retreat on 8 subpoenas, with a 9th likely gone soon. At this rate, the optics are devastating. It looks less like strategy and more like desperation, leaving dozens of remaining subpoenas hanging by a thread. The bigger question hanging over this entire situation is what Blake Lively hoped to achieve by starting this wave of subpoenas in the first place. Instead of silencing her critics, the backlash has only made the story louder, drawing more attention to every move she makes. Legal experts are already suggesting that this approach may damage her image far more than any negative coverage ever could. Commentators are pointing out that when celebrities use their influence in this way, it often sparks conversations about freedom of expression, privacy, and the limits of power. Every withdrawal feels like another admission that the strategy was flawed, leaving observers to wonder how many more names will eventually be cleared. With public trust shaken and scrutiny building, the spotlight is now brighter than ever, and the outcome of this case could set a precedent that shapes future battles between fame and accountability. They refuse to withdraw every subpoena, targeting only those strong enough to push back, leaving countless others defenseless. Many creators lack resources, never saw the notice, or dismissed it as a scam, and now their most private information hangs in the balance. Google has already warned that without immediate motions to quash, it could be forced to hand over sensitive data directly to Blake Lively, making this threat far more urgent than any August 5th deadline. By tomorrow, she could potentially gain access to over 30 creators' credit card details, bank accounts, home addresses, personal numbers, email logins, and even linked backup accounts. And for anyone who understands Google's systems, this is terrifying. Setting up YouTube requires third-party authentication, and once inside, an intruder can hijack the creator studio, seize AdSense accounts, manipulate advertising dashboards, redirect revenue streams, and ultimately dismantle years of work. This isn't speculation, it's a looming disaster. Directly to them, hackers could reroute revenue streams, wipe entire channels, or destroy years of work, and the moment Blake began demanding backup accounts, recovery emails, and even IP addresses, alarms went off. Was this an attempt to secretly infiltrate creators' platforms? Yesterday, Shasty voiced her deep fear in a video, warning that Blake might weaponize this information to push for gag orders silencing critics. And while Shasty, one of the kindest voices in this space, spoke with sincerity, the legal reality is different. In this jurisdiction, protective orders cannot silence public commentary. Blake would need restraining orders, requiring undeniable proof of harassment like repeated calls, invasive emails, stalking, or explicit threats. But all we have done is report on a matter of public interest, without contacting Blake, her family, or anyone connected to her. The only real victims so far are Steve Sorowitz's family, who endured an arson attack and kidnapping threats. This fight isn't about gag orders, it's about control, and Ryan's background in technology, marketing data, and programming firms like MNTN raises deeper questions about motives, influence, and strategy. The truth is chilling. Ryan's long trail of tech ventures paints a picture far darker than it seems. His work with MNTN, a high-level programming company built to drive aggressive marketing strategies, shows his access to data powerhouses. Add to that his history with Mint Mobile, now under fire in California for secretly recording customer calls, mishandling data breaches, and repeatedly failing to protect consumer privacy, and the pattern becomes undeniable. With such deep ties in technology, isn't it possible he could exploit these connections to infiltrate our accounts, erase our platforms, and sabotage our livelihoods? Even more disturbing is the thought that Blake wants our personal details on record, exposing names, phone numbers, and addresses so her loyal fanbase can be weaponized to do her bidding. She has already manipulated emotions, painting herself and Ryan as victims, crying danger while unleashing a wave of blind loyalty. The result: a dangerous cycle of doxing, harassment, threats, and potential criminal acts carried out by others while her own hands appear clean. This isn't about legal orders, it's about revenge, control, and silencing voices. If the courts fail to intervene, it's clear Blake and Ryan won't hesitate to target anyone who refuses to bow. Just look at Richard Fedk in Vancouver, a respected photojournalist for outlets like Entertainment Tonight and US Weekly, who was framed as violent simply for doing his job, proof they'll twist reality itself to destroy their critics. Ryan Reynolds allegedly tried to drive a photographer off the road, slamming into his car, but the truth, according to Richard, was the opposite. Ryan lashed out, punching the window, kicking the vehicle, and then ran to police claiming he was the victim. Witnesses recall Ryan exploding at paparazzi, screaming on highways, and demanding why anyone dared follow him. On a movie set, an extra practicing with a camera was suddenly cornered by Ryan, pinned, and interrogated as if filming him was a crime. Richard Fedak revealed Ryan's obsession. He cannot stand anyone profiting from his face or his name. Magazines thrive on his image, yet instead of embracing the publicity, he wants to dominate the money, the narrative, and the power. Fedak went further, calling him vain, narcissistic, and even a psychopath, convinced this entire lawsuit is Ryan's creation, not Blake's. To Fedak, it's history repeating itself. Once he was the target, now creators, critics, and rivals are branded as predators while Ryan plays the victim, orchestrating chaos from the shadows. Creators are being painted as dangerous, yet the real MMO here is paranoia, delusion, and the reckless habit of falsely accusing innocent people of crimes, and shockingly, until now they've escaped consequences, with no court ever daring to hold them accountable, which is a massive problem that strikes at the heart of justice and free expression, leaving countless voices silenced and reputations destroyed. So tell me, what do you honestly think about this entire scandal in the comments below?